In June of 2024, the Procurement Policy Division, Ministry of Finance, Government of India, released the guidelines for arbitration and mediation in contracts of domestic public procurement. As per the guidelines, arbitration should neither be a routine nor a default choice in contracts of domestic public procurement. As a norm, arbitration may only be restricted to disputes that are valued at less than 10 crores. So the guidelines seek to restrict government entities or agencies from opting for arbitration for disputes that are valued at higher than 10 crores. Do you think this restriction will pass on to maybe the private parties also who choose arbitration, given the time, cost, the avenues of setting aside and challenging enforcement that the government has highlighted as certain impediments?
So, Shruti, while these issues that you mentioned are also mentioned in the guidelines, it's not as if these issues have not been prevalent in the arbitration practice. And while these guidelines highlight these issues, they also lay down the advantages of arbitration. So, for instance, the guidelines recognize that arbitration is quick and convenient and in comparison to litigating before courts. And secondly, the finality associated with arbitration by virtue of the 2015 amendment to the Arbitration Act and in light of recent case law. So that definitely instills some sense of confidence in parties for choosing arbitration as a dispute resolution mechanism. And thirdly, and most important in my opinion, is that arbitrators, the parties have the ability to choose arbitrators who can be experts in the subject matter of the arbitration that is present. For instance, if it is a maritime arbitration, someone from the industry of maritime law would definitely be more efficient and definitely be able to appreciate the facts and circumstances of the arbitration compared to someone who is not from the industry.
So I now want to highlight one of the practical issues in arbitration that the government has discussed in the guidelines. So one thing that the government has observed, or seems to have observed, is that when there is an arbitration clause in the contract, just because there is an arbitration clause in the contract, the parties sometimes avoid reaching a commercial amicable settlement and invoke arbitration. And even in the process of arbitration, because it's an adversarial process, the claims tend to be a little inflated, which might lead to parties reaching, even if they do reach a settlement, the settlement might be far from the truth and far from the intrinsic claims that the parties have. So what are your thoughts on this?
Well, in practicality, before arbitration is invoked by the parties, they usually tend to undertake attempts to resolve the dispute amicably. If parties want to actually ensure that such efforts take place, they might opt for a tiered arbitration clause in the contract. A tiered arbitration clause in the contract simply mandates that the parties undertake a negotiation or a mediation process, failing which arbitration may follow. In any case, before arbitration is invoked and during the stage of drafting your pleadings, the parties may undertake an assessment of their true intrinsic claims. When such an assessment takes place, the parties identify what the true intrinsic value of their claims are, which may in turn actually encourage amicable settlement of disputes.
The government in the guidelines states that one of the peculiarities of government agencies or entities as a disputant is the fact that non-arbitrariness and fairness is a necessity in their functioning. Now, this makes it difficult for governments who are parties to accept arbitration awards because they might vary from other similarly placed contractors in a different arbitration or who are not in an arbitration, right? So, how do you think this lack of precedence or precedential value in arbitration has an impact on parties, and is that a consideration for them to choose or not choose arbitration?
That's actually a very good question. I think irrespective of which dispute resolution mechanism a party opts for, they do certainly look for predictability of outcome. And I understand the concern that these guidelines state that because there are no binding arbitral precedents as such, predictability can be an issue. But I do think that there are enough checks and balances to account for those things. For example, even though arbitrary precedents are not binding on tribunals, tribunals still look at them as persuasive authority. And they do try to make sure that their decisions are consistent so that there isn't a situation wherein very similar fact patterns, very different decisions are coming out. And second, another checks and balances which exists is that an award which violates the law of the state can always be set aside. So tribunals would not be taking very different positions from what is being given by the courts of the state. So that also ensures that the decisions are not too erratic or too arbitrary in that sense. And it's always good to have flexibility. Having that flexibility with the arbitrary tribunal also allows them to evolve the law. And therefore, they're not bound by the rigidity that is often complained of in the court system. So while predictability is important, I do think there are enough checks and balances in arbitration to account for that.
Congratulations to you on your appointment as the Vice President of the Arbitration Bar of India. After the guidelines were issued, the Arbitration Bar of India and the Indian Arbitration Forum expressed certain concerns regarding the guidelines, and the Arbitration Bar of India also suggested a withdrawal of the guidelines. Could you share with us what your prima facie view on the guidelines is?
Sure. No, I think first of all, thank you, and it has been a great step in the ecosystem of arbitration in India that we have now formally launched Arbitration Bar of India, bringing in different practitioners as part of this bar to strengthen the arbitration ecosystem in India. Definitely, this was one agenda that we took up immediately after our formation, because we thought that while the guidelines do talk about both the advantages and the disadvantages of arbitration, fairly so, I don't think anybody can run away from the part that there needs improvement in certain areas of arbitration. But to simply suggest that therefore the arbitration is not a preferred method of dispute resolution is not entirely correct. I feel that if certain parts of arbitration is not working out well, then it's like dealing with a body, right? When you are dealing with your own self and certain parts of your body is not working, you don't kill the body itself. You need to deal with the issues that the body is suffering. So I think arbitration has worked very well across the world. Since 2015, this government has done tremendous work in making arbitration system work. Yes, it's an alternate dispute resolution system, and I have been talking about it that it should be actually a parallel dispute resolution system because that changes a complete mindset from alternate to parallel. And we need judiciary, we need support of the judiciary as part of this parallel dispute resolution system, but we don't need to completely discard it. Since 2015, this government has done several measures, implemented amendments in 2015. Immediately thereafter, they formed a high-powered committee to institutionalize arbitration in India. Then they came up with 2019 amendments, and now, as we speak, we already have a committee report in 2024, which suggests seminal changes to even the current regime, and which is all fine. But what these guidelines do is, while they talk about advantages, they talk about disadvantages, but they somewhere, propagates or at least prefers mediation and court system over arbitration. And that may not be entirely advisable in the current Indian scenario, where the business environment needs some semi-formal way which takes away the rigidity of court system but brings in the informality of arbitration system for adjudicating the dispute. And more importantly, the government would always be conservative and reluctant in mediating their disputes rights, while it is a great suggestion, and it's a very welcome suggestion. but it's not easy to mediate or settle government disputes because of many issues involved in terms of arriving at a settlement agreement. So I think the mid path, which is the arbitration, which is semi court system in that sense, and informal with flexibility of bringing in rules and bringing in methods to resolve those disputes innovatively, is the way forward.